before the break, I looked at some of the cases, and I said I'd take you to some of the academic authorities in the absence of very clear authority case law on this point, exception to Forest 2. Roderick Badshaw and Nicholas McBride, in their tort law textbook, have a section on a principle, a similar principle. This is found at the start of the extract is electronic bundle page 1294, and the section which deals with this issue is 1325. And the authors label this principle as the interference principle, but to all intents and purposes, it's very similar to the principle we identified in the Tavares and Steele excerpt. On 1325, at the top of the page there, one sees the principle set out by the academic authors, they express it as follows: if A knows or ought to know that B is in need of help to avoid some harm, and A knows or ought to know that he has done something to put off or prevent someone else helping B, then A will owe B a duty to take reasonable steps to give B the help she needs. And they look at some of the cases, including particularly the Kent and Griffiths case that we looked at a little bit earlier. Now, what is interesting, I think, from that excerpt, the way in which that principle is expressed, it's a little bit different in one sense to the principle, the exception that expressed by Tavares and Steele, in the sense that it goes beyond, I think, the notion of prevention, talking about something a little bit less stringent than that, putting off for a person. I think that's relevant in this case for the reasons that we discussed a little bit earlier on, because in the Court of Appeal in this case, as we know, Lord Justice Stuart Smith set the criteria relatively high in his decision in the Court of Appeal. It's at paragraph 8 of his judgment, which is electronic bundle 127. I'm not going to take you through that excerpt because my learned friend has already taken you to that. And the conclusion being something akin to coercion or physically stopping the putative rescuer was required. Now, clearly from the little excerpt I've just read out in the academic, in the textbook, Bagshaw and McBride's textbook, illustrates the point we've been trying to make, that actually that's too high a standard. It's not appropriate to require something as stringent as coercion or physical stopping. And hence, I think the use of the reference to interference, the principle as discussed by the authors, is a different one, which extends to conduct which would put off, would dissuade, would hinder a rescue attempt. And it's interesting to note that Nicholas McBride, in a case note in the University of Cambridge research papers, which can be found in electronic bundle 1286, case note on covering this case in the Court of Appeal, Tindall in the Court of Appeal, at 1290, Nicholas McBride looks at the Court of Appeal decision in this case and says that it was flawed and that actually the claim should have been allowed to proceed to trial on the basis of the interference principle as we've just described it, saying that if you change the letters A and B and put in instead the police and the claimant, that actually it's Tindall is a good example of this type of this exception, this principle, and so that's in his that's in the case note, which is reproduced for you at 1286, and the key part in relation to Tindall is 1290. Another academic, I won't take you to it. I'll just give you the reference. Professor Donal Nolan of the University of Oxford also supports this interference principle in an article in the LQR, which again is found in the materials. Starts at 1235, electronic bundle 1235, and the key section is at 1250, where Professor Nolan supports the existence of this principle, the interference principle, a sort of development of, as we've seen, to Forrest and Steele, and he describes it as also including conduct which dissuades.
Which page are you looking at?
And
which page?
1250, electronic bundle.
Yeah.
You can see that there.
Where are we looking on that page?
So let me just pull that up. Foot of the page. Foot of that page starts. The second point is that sometimes additional damage comes about because the defendant's conduct dissuades or prevents a third party from going to the claimant's assistance. And then over the page there, 1251, there he engages directly with the interference principle and sets it out and supports, I think, the exposition of that by McBride and Bagshaw, going to the midway through that page 1251. So that's the academic learning. One other point, just to respond to a point made by Lord Leggett about the relevance of the Police Act 1996, section 89(2, which is in relation to obstruction resisting a police constable in execution of duty. We say that's not necessary. I think it was a point you made. It's a matter of common sense, of course, that when the police turn up at an accident scene, you're going to stand down. But to go a bit further than that, requiring coercion would mean then that, in effect, what one's saying is actually almost conduct which would almost infringe the actual provisions in that statute, in the sense that you'd be resisting. If you have to be coerced, it would be necessarily that you're resisting. And that strikes us as too high. It's just a natural that Tindall was stood down when the police arrived. That's common sense, and that's reinforced by the legal duty. In effect, there is a legal duty which reinforces that, as found in that statute as well. Finally, just a point I think to make about the categorisation, which has been raised on a couple of occasions. There is an overlap, as we've seen, between this exception and making matters worse. I think in many cases the factual scenario could be analysed either under this exception or, as we saw early on, as a making matters worse. Perhaps what this exception does, though, is provides an intellectual framework in some cases to understand actually what the requirements are in terms of the actual interference or prevention or hindering of the rescue, if the making matters worse scenario is of that nature. So in a sense it may be a subset of that, even though it is categorised often as an exception rather than as making matters worse is outside the rule. I think I've covered...
and you would say, as I understand it, that any requirement of coercion or physically stopping someone doing something would be an unprincipled restriction?
Yes, it would be unprincipled. It would be illogical because it's requiring something that in effect goes contrary to what one would expect in that scenario. So with Kendall, the police arrive. To say then that it will only be engaged, the principal, if he actually has to resist standing down, doesn't make sense, because he's someone who would be very cognizant of course, as an ex-gritter professional. He was a local advisory gritter, would very well know the obligations, the legal obligations we just referred to under the various acts as well, that when the police arrive, not only it makes sense to hand over to them, but there's a legal obligation to do that, otherwise one would risk falling within the sanctions we described. So that, I think that doesn't make sense. Why? The level of requirement doesn't make sense, and why should that? Why difference between coercion and voluntarily satisfying legal obligations? Why should that be determinative of the existence of a duty in this scenario? It doesn't seem to be correct. That should be the litmus test. I think that's.
If you strip it right back to the principle would seem on the face of it to be that you are causally responsible for the person who might have carried on with the rescue or intervened to carry on the rescue. You are causally responsible for them not doing that. Isn't that the ultimate principle? So even putting off or preventing is sort of almost there, because it may well be that putting off is as close to that causal principle as you can get. But if we're talking about making things worse off, I think it is a causal idea on the face of it. But as I would see it at the moment, it's difficult to see why you should have to sort of superimpose something more stringent like coercion or physically stopping. It's hard to see what the principled reason for that would be.
What the underlying rationale for that?
Well, that may be the same way of putting it. Yeah.
Yeah, I think that's absolutely correct. Agree with that.
Well, I take what Lord Justice Stuart Smith was saying was that Mr. Kendall chose to go away and the police weren't responsible for that. That was the sort of idea that he was putting forward, I think. But what perhaps that overlooked is that that was the entirely predictable effect of the police arriving, which anyone in their position could have realised would be the likely consequence of their
arrival and taking control, undertaking a series of acts as well when they did that. I think, and also the legal obligations that we discussed a bit earlier as well. Knowing under an obligation to actually allow the police to do that, as with the fire brigade. The fire brigade also.
Well, that's a sort of extra point. Really.
It's an extra point
because if I would have thought that if a member of the public had come along and said, "Well, you go off to hospital now. I'll flag down the traffic," then they would have taken on. They'd be in the same position.
Well, it would have to be foreseeable. I accept that. Causation plus foreseeability.
Foreseeability point that we discussed earlier on. Those are my submissions. Unless you have, we will also make sure we get copies of the academic articles that Lord Burrows.
Thank you very much.
Yes, I should mention I don't have in electronic form the additional pages that were referred to earlier this morning. I don't know if my colleagues have.
I haven't looked in our bundle, but I think we might.
They are there now, are they? Okay, I may have checked too early.
Which is the
Apparently the registry didn't want them in electronic format, but we can of course. You've got separate one. That's not a separate one. We can
a separate bundle.
Yeah. Supplementary.
Supplementary, I think. Yeah.
It hasn't come to me.
Well, I've got a collection of things. I'm not sure whether there's nothing called. There are various things like Emergency Workers Obstruction Act.
Yes.
Is that it? Was that the point?
No.
There is that, but I think Lord Hodge is referring to something else, which was replacement.
Oh no, well I don't think I've got those either.
Well, then we maybe need to make sure that you get that in a separate electronic files.
Yes. Well, we need it in some form.
Which we'll get that as well with the articles we refer to.
Thank you very much. Yes.
Well, my lords, my lady, I will be dealing with the appellant's arguments on control, and they are to be found at paragraphs 79 to 102 of the written case, which is 82 to 90 of the electronic bundle. What the appellants are calling the control exception to the emissions principle is described in Tafaris and Steele's article, and a segment, of course, which has been cited in the various recent Supreme Court authorities, as a situation where A, who in this case would be the police, has a special level of control over a source of danger, which in our case would be the ice, such that they are under a duty of care to prevent harm occurring to person B, in our case Mr. Tindall, as a result of that source of danger, namely the ice. As to the requirements of the control exception, Lord Toulson in Michael at paragraph 99, and that's 715 of the electronic bundle, in a passage which is cited at paragraph 79 of our written case, which is 82 of the electronic bundle, identified Dorset Yacht as the classic example of a control case, and explained in that passage at paragraph 99, with reference to the case of Couch, that such a case required the analysis of two special relationships: the defendant and the third party, so that's the police and the ice, and the defendant and the claimant, so in our case the police and Mr. Tindall. My lords, my lady, in my submissions I'm firstly briefly going to take the court to the factual and pleaded basis for the application of the control exception. Secondly, I'm going to identify 5 propositions which address the Court of Appeal's rejection of the control arguments and the objections that are set out in the respondent's written case. And thirdly, I'm going to expand on those propositions in turn. So turning first to the factual underpinnings and the pleaded case on control. In terms of the pleaded case on control, I'm just going to give you the references to the particular claim without pulling them up. The facts relating to the police officer's attendance and taking control of the scene are set out at paragraphs 30 to 40 of the particulars of claim, and that's page 164 to 165 of the electronic bundle. The averment that the police took control of the scene, then relinquished it, is paragraph 57 of the particulars of claim, page 167 of the bundle. There is a further reference to assuming control and relinquishing it at paragraph 59H of the particulars of claim. And I'll just pause there for a second, because I think that's one of the pages that the court is missing. There was a page missing in the particulars of claim. So again, we'll make sure that the court has those at least overnight. And finally, in terms of the particulars of claim, causation as regards the police is dealt with at paragraphs 67A to 67C of the particulars of claim, which is page 169 of the electronic bundle. The actions of the police at the scene are set out in narrative detail at paragraphs 3 to 7 of the statement of facts and issues, and that's pages 42 to 43 of the electronic bundle. In short, it is the appellant's case that the police officers took control of the scene by attending the scene with 2 police vehicles. One police vehicle arrives at 5:03, and by 5:06 a.m. there are 2 vehicles there, and then remaining there until 5:26 a.m. Putting out a police slow sign to slow traffic down, sweeping the road and checking for and removing debris from Mr. Kendall's car, and slowing down traffic through the use of blue emergency lights in conjunction with the other emergency services at the scene whose attendance they were managing. Of course, there were the police and the ambulance service were also there. It is of further note to consider what is said by the respondent about the control exercised by the officers, and the relevant averment is at paragraph 32D of the defence, and that can be found at page 177 of the electronic bundle. It says, insofar as the officers took any control of the accident scene whilst they attended to Mr. Kendall's accident, they did so only for the time of their attendance at that accident, and whilst they secured his safety.
Just to be clear, is your case on this point one that you say would be applicable if Mr. Kendall had never existed? Or does it do another way of coming to the same thing because it displaces
it runs separately. It runs separately. So in terms of the...
So if you come along and go away again, you incur potentially a duty, whereas you wouldn't have incurred one if you'd never come in the first place.
So if you applied the making matters worse analysis that we were talking about this morning, you wouldn't get a liability in this instance,
no.
Because the ultimate result is if you hadn't turned up, it would be the same. So as leaving and then abandoning your control. The key aspect to this case is the assessment of whether or not control was imposed upon that situation or the source of danger.
It seems illogical that you should be liable in the situation where you come along for a while and then go away, if you wouldn't be liable if you didn't turn up at all, which would seem even worse.
Well, it's the exercise of control that is the focus in this instance. So it can be shown that the relevant and the requisite degree of control is exercised by the private individual or the public authority who turn up at the scene, then it's that places upon that public authority or individual the obligation.
Well, that suggests if you come along as an individual and start helping, you've got an obligation to stay there indefinitely. Well, that can't be right, can it?
Well, not indefinitely. Only the scope of duty is not limited to that. It would be...
Well, at all. I mean, why if you as a passerby come along and start to help, unless you dissuade others, we're putting that aside for the moment, why should that put you in a position of liability when if you've never stopped in the first place and you've done nothing, you would not be liable?
Well, so in relation to the passerby, we don't say it's our case that analogy wouldn't necessarily work because your passerby is highly unlikely on the facts to be able to demonstrate on the facts that individual had taken control of the situation. The requirements for control are stringent.
By standing and waving cars down?
Well, we don't say, to be quite clear, it's not our case that Mr. Kendall took control of the situation. Our case is, well, we don't run it in that particular way, but it's not our case that Mr. Kendall had taken control of the situation. We would never be saying that Mr. Kendall had any liability. Of course, on the facts of this case, he was dissuaded or encouraged to leave by virtue of the police's attendance. But in terms of the analogy with a private individual turning up and helping to wave down, and the suggestion, well, it can't possibly be right that such an individual would potentially incur a liability, our case is the test for that is whether the requisite degree of control is exercised by that individual, which would be unlikely that an individual would be able to do that, and certainly in a scenario of waving down traffic, that would be unlikely. But the situation is different in the current circumstances with a professional rescuing organisation which turns up with vehicles, lights and all of the training, and equally may be the same, you might find the same in the context of a private rescue organisation with all of the same equipment. But in terms of an individual member of the public, the test is the same, but it is unlikely that individual, in relation to that individual, that they would be seen to have established control. Just in terms of testing Lord Leggett's proposition, in terms of just to censor any of this, one potential hypothetical would be the police turn up at a scene where there is a wild animal threatening members of the public. They use their training, they take control of the wild animal and put it under control, put a leash on it, and then decide for whatever negligent reason, having controlled the wild animal, which was causing risk to members of the public, just to abandon it, drop the leash and walk off. And of course the animal potentially injures somebody afterwards. And we would say that they would have controlled the source of the danger in that situation, the wild animal, and having established control, they negligently relinquished control, and therefore they would owe a duty to those who they could reasonably foresee would be injured by a wild animal on the loose. And we would say there shouldn't be any, we can't see that there should be any particular objection to the proposition that liability can be imposed in those circumstances. The restriction on it comes from the stringent requirements of control. And when I come on to my propositions in just a moment, I'll demonstrate how that applies and why, for example, therefore we are able to distinguish this case from many of the other cases which are cited by the respondents, in particular the highway agency cases that Mr Bowen dealt with earlier in the context of making matters worse. So, my Lord, then just turning to the propositions, I have 5 propositions to make, and I'll identify them all now and then I'll come back to them and deal with them in a bit more detail. The first proposition is, for the avoidance of doubt, the appellants do not, in the present case, seek to rely on assumption of responsibility as a separate exception to the omissions principle. Second, the appellants do not seek to argue before this court that the control exception is engaged merely where a party has the potential to control a source of danger, be it a third party or a scene. Third,
merely where a party has potential to control.
Yeah. So we don't say that merely where a party has the potential. So they have powers, but they're not on the scene. They haven't exercised that control. That's not enough. Third, under the control exception, there is no need for the party exercising control to have made matters worse or to have created danger. Fourth, the control exercised by the police distinguishes the present case from examples of a fire officer and a member of the public scenarios which were raised by the Court of Appeal and the respondent. And finally, fifth, there are sufficient features in the present case to differentiate Mr Tindall from all other road users or members of the public generally, and there was further no need for there to have been a pre-existing relationship between Mr Tindall and the police. As I said, those propositions address the issues that were raised by the Court of Appeal and the respondents in their written case. And I'll just give you the references without pulling them up in the Court of Appeal judgment. It's paragraph 70 to 74 of the judgment, which is 148, 149 of the electronic bundle. And within those paragraphs, there is also a reference back to the reliance that we had placed on Gibson and Orr, and the judgment deals with that in more detail at paragraph 63 to 65 of the judgment, which is 146 to 147 of the electronic bundle. So turning then to the first proposition, assumption of responsibility is not relied upon by us as a separate exception. And I can deal with this relatively briefly. In the present case, the appellant's submission is that as a result of the control exercised by the police over the scene, which represented a source of danger, responsibility was attached to the police by virtue of the control exception in relation to future users of the road in that location, whilst the ice hazard remained in place, absent any warnings as to its existence. Whilst the language of assumption or attachment of responsibility is being used and was used by the Court of Appeal, all of the most recent Supreme Court authorities, Michael, Robinson, Poole and HXA, have recognised control and assumption of responsibility as representing different principles and different exceptions to the omissions principle. So just for the absolute avoidance of doubt, although there is some shifting in the language in the Court of Appeal's judgment, it is not our case that this is a case which engages with the assumption of responsibility exception, and certainly we do not contend that there was any pre-existing relationship between the police and Mr Tindall which could potentially give rise to such an argument. So, my Lords and Ladies, that's the first point. The second point is the appellants do not seek to argue that the control exception will be engaged merely where a defendant has the power or the potential to control a third party or scene. And this is a point which addresses paragraph 71 of the Court of Appeal's judgment at 148 of the electronic bundle. So, as noted previously, the appellant's pleaded case is that the police had control of the scene and then relinquished it. That's paragraph 57 of the particulars of claim, and it's also you can see the recitation of that aspect of the claim at paragraph 21 of the Court of Appeal's judgment at page 132 of the electronic bundle. And just briefly to note what is said there at paragraph 21, 6 lines down. Here it is submitted that the police took control of the scene in the dangerous road. They had the ability to control the risk posed by the black ice, or at least to influence the outcome. So the reference there in Lord Justice Stuart Smith's summary of what we were saying to the power to exercise physical control over the black ice comes in the important context of the claim that the police had taken control of the scene already by that point in time.
Should, on this principle, the East Suffolk case have been decided the other way because the authority had taken control over the wall, which they'd started to rebuild?
Well, no, we say no, and the case is distinguishable because, and I'll come to this in a moment, but in East Suffolk, the source of the danger is not the wall. The source of the danger is the incoming water, and it couldn't possibly be said on the facts of that case that they had control of the source of the danger, which is the water. They were trying to do it, but they hadn't established control. And so that we say that is therefore a different situation to the control case that we put forward, where they have control of the scene. Obviously, the ice is an inanimate object, as distinct from water, which is moving and trying to escape. The same applies, and I'll come on to this again in a moment, in terms of distinguishing from a fire officer trying to control a fire. There is a distinction in our submission between the current case, where the police have taken control of the scene where there is black ice situated, and a situation where a senior fire officer attends where there is a fire. But I'll develop that argument just in a moment, because it's one of my other submissions, one of my other propositions. But on this second point, it's not, just to be absolutely clear, it's not argued that a duty will arise in circumstances where the police have the potential for controlling the scene in the future, but do not, at the point in time when it's claimed the duty arises, have control, for example, perhaps because they've negligently failed to get control. It's accepted that such an approach would be unduly broad and contrary to the requirement that a special level of control is exercised over the source of danger. So again, the key thing is that control needs to have been exercised.
What is control for this purpose? In what sense did the police control the black ice, other than that they could have done something to warn people of it or to remove it, but they didn't?
The control comes from them being, bearing in mind, again, we have to bear in mind that the black ice is obviously an inanimate object on a...
Well, we know that.
Yeah, I mean, yes.
Your point is that it is situated, it's not moving.
Yeah, so it's situated, it's not moving, and they've effectively sealed it off. You can't apply that same logic to the situation of a fire, where there's an active fire, and a situation, as my Lord, you indicated again a moment ago, in relation to East Suffolk, with the flooding of the seawall, because the danger is not the wall, the danger is the water, and the whole point of the East Suffolk case is that no one had control of the water, and it caused the extended flooding. So we draw that distinction. You have to have exercised the control first, and what control requires will depend on the nature of the case, the nature of the danger.
You said sealed off, but they hadn't sealed off the road.
No.
Well, they
just
all they did is put a sign and have blue lights.
Well, they were there with a selection of vehicles.
Yes, but they hadn't blocked the road.
No, sorry, that's absolutely right. And I was sort of giving that as an example a situation where if you have an inanimate object, obviously if you sealed off the road, that plainly would be control.
Yes.
In the current situation, you have, obviously it's a step back from that, you have emergency vehicles, not just the police, you obviously have the police's 2 emergency vehicles, but they're also managing the emergency response of the fire brigade and the ambulance with their own vehicles. They put out a sign, there are officers out on the road. And an assessment would have to be made as to whether those circumstances are sufficient to amount to control over that scene. Now, we say those circumstances could be construed properly as having control over that scene, such that if the control is relinquished, there would be a duty, or negligently relinquished, there would be a duty to someone who's a reasonably foreseeable victim of the danger, namely the ice.
In fact, they only had one slow down sign, I think, didn't they? The car should have had 2.
That's correct, yes.
So they weren't doing anything really to stop the traffic coming in one direction.
Well,
and it does appear that the ice was right across the road because one skid was on the north side and the other skid was on the south gate.
Well, so it's absolutely right that they only had one sign. But of course, as I mentioned a moment ago, they had a selection of vehicles out on the road with flashing blue lights. In terms of the exact location of the black ice and the extent of the black ice, of course, that we have the pleadings on that, but that's not entirely clear, and of course would be something that potentially come out at trial, again, to assess on a fact-sensitive basis whether what the police were doing amounts to control or not. And of course, on a trial, it may well be that the respondents are able to demonstrate that actually, looking at all of the facts and what actually happened, that control wasn't exercised. Our case is, well, we have a pleaded case which says this amounts to control, but obviously it may well be that when the facts are tried, a judge concludes, having considered all of the evidence, that's not enough in terms of amounting to control. But on a
Can I just ask you, at the moment I'm struggling to be sure whether you can start to talk about the principle of control as applying to anybody other than people. In other words, that your starting assumption here is that it can apply to natural hazards.
Yeah.
Have you any English, and I stress English, case that has applied the control principle other than to human beings?
Well,
I mean, surely this idea was founded on Dorset Yacht. And there, what you're trying to work out is why on earth is somebody responsible for what a third party has actually done to harm the claimant. Mm-hmm. Now, if the defendant has control of the third party, that starts to look actually pretty straightforward. Well, if you've got control in certain circumstances of the third party, you can be held responsible. But I'm not convinced that it works if you try and apply it across to a natural hazard.
So one example would be Goulburn and Hargrave. Although that was a case, that was where lightning strikes on somebody's land, starts a fire, and the liability is found because it is said that the person whose land that the lightning struck on and created the fire didn't take proper steps to prevent the fire encroaching onto his neighbour's land. Now, I hesitate.
That was surely not a negligence case. That was some kind of.
It was an occupier liability case. That's right. And there is a. I mean, certainly in the academic authorities on this, they do, and you would have potentially seen that they talk about in the context of control that you can also interpret occupier liability cases in that sense. On my Lord's point as to whether you require an individual, sort of a person as perhaps distinct from, for example, an animal, Lord Morris in Dorset Yacht gives the example of wild animals and keepers, and you'll find that at 1039D of the report, which is at page 545 of the electronic bundle.
545, did you say?
Yes, 545, and that's of the report 1039, and it's at D. If someone chooses to keep a wild animal, it by common consent be assumed he was under a duty to prevent its escape, and he then goes on to talk about. He's giving examples there of circumstances in which it will be said that there is an obligation to prevent the escape of something dangerous. And of course, that's in the context of wild animals and keepers. I can't immediately, other than the example I gave you of Goldman and Hargrave, give you an example of explicitly the control exception being described as the means for reaching liability in the context of a live creature or human being. But of course, that's something we'll have a quick look at it overnight, and if we can provide you with some authorities on that. But conceptually, in my submission, that shouldn't provide a difficulty. If you read, and I'll take you through them, and perhaps given the time I might just have to give you the references rather than going through them in any great detail. But if one reads through the judgments of Lord Morris, Lord Diplock, in Dorset Yacht, you'll see that one of the things that they particularly talk about in the context of what is required for control is that more control will be needed, and you'll need to show, and in terms of the people to whom you owe the relationship with, the category will be smaller in circumstances where what you're talking about is a person who is responsible for their own actions, for example, as distinct for one of the distinctions they draw there is between the actions of an adult and a small child who can't be held responsible for their own actions. So, for example, in Dorset Yacht, they talk about the they cite, and in fact reliance is placed upon the case of Carmarthenshire County Council and Lewis in the judgments. And if I just, first of all, you'll see that initially cited at page 545 of the bundle, which is the passage we were looking at a moment ago in relation to Lord Morris, where it says, it will be universally known that the movements and activities of young people may lead to perils not only for them but for others. Consequently, there may be a duty of care which may be owed to any one of a class of persons. It could be owed to all persons who could reasonably be foreseen as being liable to be injured by failure to exercise reasonable care. That was the proposition in Carmarthenshire County Council and Lewis, and then it goes on to describe the facts of that case, which is effectively a duty owed by the nursery school where there was a 4-year-old boy in their care, and he escaped, resulting in an accident whereby a lorry driver was killed.
But I mean, that again is fairly close to Dorset Yacht. The third party that causes the damage was a person in the control of the defendant,
who's acting in a positive way and causing harm, which you're then made responsible for. Here, all we've got is somebody who warns of a hazard for a while and then stops warning of the hazard. And I can't see any difference between that situation and one where they never start warning of it in the first place. Well,
the distinction is that they have, as I think I mentioned earlier, the distinction is that they have met the stringent test of having controlled those circumstances. I go back to the scenario that I take.
But why, morally, should that make any difference at all? Why should you be in a more responsible position because you've helped out for a while than if you never help out at all? And that's the obstacle I just can't get over. Well,
I'll just posit another hypothetical. Of course, that's a question, difficult question to answer, but I suppose one answer to that question is by exercising control there in a less foreseeable sense, nobody else is coming to that situation to take control and to deal. Well, if you've displaced somebody, then we get back to that. Or if you've led other people to believe that you're going to carry on acting in that way, that might be a basis. But there's no suggestion here that anybody had been induced to act other than going back to the argument about Mr. Kendall. But why would it make, so I pose this question hypothetically, why would it make a difference? So, for example, the case that's cited by the judges in Dorset Yacht is the case of Smith and Lurs, which was a case where adopted parents were made responsible for there was a query as to where adopted parents were responsible for their adopted child who injured somebody with a catapult. So why? And
these are all kind of a vicarious responsibility type of situation, aren't they?
Well, no. I mean, in that case, albeit ultimately no liability was found. The no liability was found because it was said the parents had done as much as they could have done in terms of instructing their child not to use the catapult. But in the context of the case, and of course you've got the citations from Smith and Lurs in Dorset Yacht, and I'm concerned about. I'll hopefully take you to those in a moment. But the point in that case is that one of the arguments is whether or not the parents should be in control of their adopted child.
Right.
Okay, you may say, well, because they're in a position of sort of loco parentis, but just in terms of this hypothetical, and of course you make your lordship and your ladyship may conclude, well, you don't think any liability should arise in these circumstances. I gave you the hypothetical of the police and a wild animal and controlling it and then just deciding they're going to abandon it. Perhaps another hypothetical, the police come across a hole in the road. They fence it off. They fence it off for an hour or so, and then they simply decide to take all of the restrictive measures away and go off because they want to go for lunch. Query in those circumstances whether the police should be held liable for having had control and then relinquishing it. I mean, ultimately, if the court concludes that in those scenarios there shouldn't be any liability on the police, then of course that's going to translate to the facts of this case. But in my submission, certainly when we've looked at this, those are the kind of scenarios where we would contend that there should be a liability in those instances on the police or indeed in anyone in the circumstances of anybody who takes...
And you say there's a relevant distinction between that situation and one where the police come along, look at the hole in the road and decide not to put up a fence in the first place.
Yeah, the key distinction is the controlling factor of that is the control that they apply to that situation.
But on the facts, it has no causal significance at all, that their brief intervention. It made no difference to what happened.
If you apply the counterfactual as we were doing earlier, but in relation to a different part of this case, it's absolutely right that you would say there is no difference between them not turning up at all and turning up, applying control to something, and then disappearing again. That's right, unless, of course, there's an argument which deals with putting off another rescue. I completely accept that. This is a separate route to liability in this case, but it's not what I said. It's not one that if you apply the making matters worse test that you would be able to demonstrate they have made matters worse, because it plainly the result will be the same either way. As I said, but the controlling feature of it is that the public authority, the police in this instance, must have taken control in the first place, and that is why this case, we say, if you accept that, is distinguishable from all of the other cases that are cited. East Suffolk, as I said earlier, because they never had control of the water or the flood. Ansell, because the officers never took control of the scene where the diesel spillage was situated. Stovin, whilst the Highway Authority had recognised the danger presented by the land bank and had the potential to control the situation, there's no point at which it can be said that they actually took control of the scene. The same again for Gorringe. There was no suggestion that Calderdale Metropolitan Borough Council had control over the slow sign or the area involving the sharp crest of the road. They had the potential to control it, but they never actually controlled it. They were not physically exercising that control. And then finally, in Sandhull, which was a case premised on the contention that the Highway Authority should have had control over all of the trunk roads in their area, it cannot be properly said that the local authority would have had control over all of the trunk roads, albeit they would have had the potential to exercise control over those trunk roads. So that deals with my point 2. Point 3 is the control exception does not require the party exercising control to have made matters worse or to have created the danger. And the starting point for that is Lord Toulson's recognition of control as being an exception to the general principle that a person should not be liable in damages for failing to prevent harm caused by another. And that of course, is the paragraph 99 quote in Michael, and an analysis which is consistent, of course, with the Tavares and Steele summary, which has been approved by this court. Given that control is an accepted exception to the principle that there can be no liability for failing to confer a benefit, it cannot be correct that the control exception requires the controller to have made matters worse. To require the controller to have made matters worse would take the controller outside the scope of the omissions principle and therefore denude the control exception of any value or relevance. At paragraph 72 of the judgment, the Court of Appeal concluded that the appellant's reliance on Gibson law was misplaced, and at paragraph 63 to 64, where the analysis provided, reliance is placed on the fact that in the current case, or indeed in Gibson and Orr, the police had not made matters worse. And in my submission, respectfully, the Court of Appeal erred in that respect, because there is no requirement for the controller to make matters worse where the control exception is being relied upon. The next related question to that is whether there is a need for the controller to have created the danger. And my submission, contrary to paragraph 74 of the Court of Appeal's judgment, there is no requirement, insofar as the control exception is concerned, for the controller to be responsible for the creation of the danger through its control of a third party. Now, I accept that liability in Dorset Yacht and in Couch could also be explained on the basis that the relevant tortfeasor had created the relevant danger. And indeed, of course, as I'm sure your ladyship will have noted, Lord Reid described Dorset Yacht in Robinson as a case where the public authority had created a danger that would not otherwise have existed. However, the mere fact that the circumstances of cases can fall into more than one of the categories of exceptions to the omissions principle does not mean that there is also an overlap in the required elements of each of those exceptions. And to understand the requirements of the control exception, it's helpful to look at the judgments of the majority in Dorset Yacht. And as I mentioned a moment ago, Lords Morris, Pearson and Diplock placed central reliance on the judgment of Dixon J in Smith and Lewis, and the most complete recitation of that passage can be found in Lord Pearson's judgment, which is at 561 of the electronic bundle. And you'll see that's at 1055 of the report. It starts just above C. In Smith and Lewis, Dixon J said, apart from vicarious liability, one man may be responsible for the harm done to the latter by a third person. He may be responsible on the ground that the act of the third person could not have taken place but for his own fault or breach of duty. There is more than one description of duty for the breach of which may produce this consequence. For instance, it may be a duty of care in reference to things involving special danger. It may even be a duty of care with reference to the control of actions or conduct of the third person. It is, however, exceptional to find in law a duty to control another's actions to prevent harm to strangers. The general rule is that one man is under no duty of controlling another man to prevent his doing damage to a third. There are, however, special relations which are the source of a duty of this nature. It appears now to be recognised that it's incumbent upon a parent who maintains control over a young child to take reasonable care so as to exercise that control as to avoid conduct on his part exposing the person or property of others to unreasonable danger. Parental control, where it exists, must be exercised with due care to prevent the child inflicting intentional damage on others or causing damage by conduct involving unreasonable risk or injury to others. That passage is relied upon by Lords Morris and Diplock later on in the judgment. I'm not going to put it up, but I'll just give you the references. Lord Morris at 544 of the electronic bundle, and Lord Diplock at 569 of the bundle. And in my submission, that formulation which is relied upon demonstrates three things. First of all, it's recognised that it is exceptional to find in law a duty to control another. Secondly, there can, however, be special relations which are the source of such a duty. And thirdly, however, no reliance is placed there upon the need for the controller to have created the danger in the first place. The focus is on control. In light of the time, I'm just going to give you the other references to the judgments of their lordships in that case, which demonstrate that the key facet of the case is control and not the creation of the danger. So Lord Morris at 544 of the electronic bundle 1038F, and then going on to the next page 1039A, which is 545 of the electronic bundle. And then Lord Diplock at 569 of the electronic bundle, which is 1063C of the judgment. In none of those cases, in none of those judgments, I should say, is any reference made to the need or requirement for the putative defendant to be responsible for creating the source of the danger in the first place. Equally, just very briefly, although it is true to say that Dorset Yacht has been construed as a creation of the danger case in a number of cases, it has equally been construed as a control case in a number of other authorities at apex level. And again, I'll just give you the references in light of the time. Lord Gough and Smith and Littlewoods at 999 of the electronic bundle, so that's 272D and 272F. And in the case of Mitchell...
Which category does he put it in?
I'm sorry? He describes it as a control case.
Control case, okay.
Yeah, so my point here is that albeit, obviously, there are some authorities which construe Dorset Yacht as a creation of the danger case, there are equally authorities which construe it as a control case. So Smith and Littlewoods, Lord Gough, Mitchell, case of Mitchell, we have Lord Hope, and that is at 754 of the bundle, paragraph 23, and Lord Brown, 773 of the electronic bundle, paragraphs 81 to 82. So, my lords and ladies, I'm just going to try and, shortly as I can, just deal with my final two propositions.
Yes, well, you are now eating, I think
yes, I know.
You are eating into your reply time, so bear that.
Right, I will bear that, and I think I'll probably try and take 5-6 minutes and deal with it as shortly as I possibly can, so I apologise for taking a little bit longer than I had intended to. So point 4, the control exercised by the police distinguishes the present case from the fire officer and the member of the public scenarios raised by the Court of Appeal and the respondent. So, as I'd observed earlier, there are two aspects, two relationships in the control exception. The control relationship, that's the relationship between the defendant and the third party, and the proximity relationship, which is the relationship between defendant and the claimant. And in terms of assessing whether or not the control relationship has been satisfied, that is a fact-sensitive assessment. The test for it, or potential test for it, is set out, and again I won't pull it out, but I'll give you the references, at paragraph 82 of Tippingjay's judgment in Couch, which is at page 1116 of the bundle, where the test is, did the defendant have sufficient power and ability to exercise the necessary control over the immediate wrongdoer? In my submission, conceptually, given the test, it must, in general terms, be easier to control the danger posed by a source of danger coming from an inanimate object than from a human being or indeed an animal, which can act independently and are thus inherently more unpredictable. As such, in my submission, what is required in the present case concerning an inanimate stretch of piece of ice on a road is likely to be less demanding than in those cases. It is important just to address the point that's made by the respondents with reference to something that's said in Capital and Counties. In Capital and Counties, the point is made that a senior fire officer who'd taken control of the firefighting at a scene could not be found to have had control for the purposes of the control exception. That's a point that's made in Catherine Counties, and it's picked up by the Court of Appeal in this case at paragraph 65 of the judgment 147. In my submission, the firefighting scenario in the current case is an example of the fundamental difference between a defendant seeking to gain control over a third-party source of danger and a defendant having obtained control. It's a point I was making earlier. Whilst a senior firefighter can take control of the firefighting, there's no suggestion that he or she actually had the dangerous thing itself, the fire, under control. And I'll just give you a reference to the case of A.J. Allen, where that argument was made and put and accepted, and that is A.J. Allen, paragraph 84, 1074 of the bundle. And then just if I then move very swiftly, just one further point on that. Of course, the other comparison that's made would be to a private individual. And again, I made the point earlier to your lordship, your ladyship, that a private individual, when assessing on a fact-sensitive basis whether what they'd done constituted taking control of the scene, it would generally be more difficult to expect such a private individual to have taken control of the scene in the same way that a professional rescue organisation with the relevant equipment and management of the scene capabilities would be doing. It would not be impossible for a private individual to do so, but certainly a single individual such as Mr. Kendall could not be said, and indeed we don't say, to have taken control of the scene. But ultimately on this point, it's our case that this is a fact-sensitive assessment, and it's a matter which demonstrates why this case should go to trial. And my final point deals with whether or not there are sufficient features in this case to distinguish Mr. Tindall from all other road users or members of the public generally. And this is, of course, a reference to the second relationship, the proximity relationship. 2 points to make. First point is there's nothing on the authorities to suggest that there needs to be a pre-existing relationship between the claimant and the defendant. We don't need to have had a pre-existing relationship between Mr. Tindall and the police. And the second proposition is that the size of the class of persons to whom a duty is owed will vary according to the nature of the third-party actor responsible for the damage. And just to explain that, where a third party is, for example, an adult human with agency responsible for their own actions, there is a greater chance that their control over their own individual decision-making introduces unpredictability, which makes the risk that they pose to others once they've escaped the control of the defendant less foreseeable, less manifest, less obvious. In such circumstances, the size of the class of persons to whom a duty is owed is likely to be tightly limited in terms of proximity, time and space, to the putative claimant, between the putative claimant and the defendant who's exercising control. Conversely, where you're dealing in this instance with an inanimate object, such as the eyes, there's no independent decision-making. The risk posed once control is lost is entirely manifest and obvious, and there's no such need to so tightly constrain the class of people at risk. So I'm just going to give you the passages which support that proposition in Dorset Yacht without taking you to them in light of the time. So firstly, Lord Morris, at page 541 of the electronic bundle 1035C to D. And again, in his judgment, at 1039E, which is 545 of the bundle. And that's where reliance is placed on the Carmarthenshire and Lewis case, which I referred you to earlier. And then Lord Diplock, in his judgment, see at 569 of the electronic bundle, 569 of the electronic bundle.
569.
Yeah, and then in terms of the judgment, internal, it's 1063A to B, and then finally 1063D. And then final couple of passages from Lord Diplock are 1070D to E, which is 576 of the electronic bundle, And then finally 1070H to 1071A, which is 576 to 577 of the electronic bundle. And then finally, in terms of couch, you'll see the point is addressed at paragraph 85 of couch, which is 1117 of the bundle. And I'll just read that because it just helps to illustrate the point that I was making. As we will demonstrate, it is also necessary for proximity purposes to assess the nature of the risk which the immediate wrongdoer posed to the plaintiff. The more specific and obvious that risk is, the stronger will be the case for holding that the defendant, having sufficient power and ability to eliminate or at least reduce the risk, had a duty of care to the plaintiff, fulfilment of which required the reasonable exercise of that power and ability. There is a need for both qualifying relationships, control and proximity, not only in cases which require the defendant to control the immediate wrongdoer, but also in cases which require the defendant to give a warning to the plaintiff on account of control having failed or not having been exercised. So that is, in my submission, consistent also with the Carmarthenshire and Lewis case, which, again, if we just recollect, was a case in which the ultimate victim who succeeded was a completely unidentifiable member of the public, somebody who just was a lorry driver who'd driven down that section of road. In my submission, that is clearly analogous to the current situation and the relationship between Mr. Tindall and the ICE is analogous, in my submission, to the relationship between the individual in that case and the child who'd wandered onto the road, who ultimately caused the accident. So, in sum and in conclusion, there is no requirement there for there to have been a pre-existing relationship between the victim and the controller, Mr. Tindall, and the police in our case, and there was no such pre-existing relationship, of course, in Dorset Yacht. It's entirely possible for the proximity relationship to be satisfied by reference to those using that stretch of road at a time when the ice was still in situ. And we contend that, as with the Lewis case, that sufficiently differentiates Mr. Tindall from the public in general. My lords, my lady, if I can assist you further, those are my submissions.
Thank you very much.
Thank you.
Just for your team's note, you've used up 10 minutes of your reply time. Thank you very much. Mr. Warnock.
My lords, my lady, how I propose to structure our submissions is this way. I'm going to come back very briefly to the facts. I'm going to look very briefly at the nature of this case with reference to the amended particulars of claim. I'm then going to look at what the law is concerning what it means to cause harm. And then I will turn to the exceptions. And after the briefest of introductions, my learned friend Ms. Davis will address you on the so-called prevent exception. And I will address you on the assumption of responsibility, control and status. My lords, if I could, and lady, if I could go to the facts first. And of course, we have the statement of facts and issues, which is a distillation of the facts taken from the particulars of claim and from the fact that we now have 3 witness statements from Mr. Kendall, and all of that against the background of the fact that there was a very lengthy inquest in this case. The statement of facts and issues is at the bundle, page 41. And if we start at paragraph 1, you see in the background the last sentence of that Mr. Kendall weighed vigorously to a passing van and other traffic in an attempt to get them to stop or at least slow down in order to avoid the risk of a further accident. Then at paragraph 2, we get what he told the control room. Paragraph 2, he called and spoke to the civilian call handler. He relayed the facts of the accident, that his back and chest were hurting and that he had tried to flag down a van, but a van had slowed but did not stop. So that's what's conveyed to the control handler about the flagging down, that he's tried to flag down a van, but the van slowed and did not stop. And if I might just divert momentarily from the statement of facts and issues, you were taken to the call log. But can I just show you how the call log starts? And it's at page 231. And this was a transcript of the call which was exhibited to Mr. Kendall's statement. And he says, "Good morning, Thames Valley Police, Kate speaking. How can I help? Hiya, I don't know. I've just had an accident in my car. I'm in a ditch upside down. Just got out. I think I need an ambulance or something. I don't know. Oh, what, are you injured? I can hardly walk. I've done my back." If I could then go back to the statement of facts and issues. We know from paragraph 3, based on all of this material, that the call lasted 13 minutes. And during that time, it is common ground that Mr. Kendall was not able to continue his attempts to flag down the traffic. And the call finishes at the time when the police arrive, and we see that in the next sentence. As he finishes his call, at 0503, PCs Irwin and Flanagan arrived at the scene in a police van, and indeed we see that on the transcript of the call itself, because Mr. Kendall is heard telling the control room that the police had just arrived. And we see what happens thereafter at paragraph 5. On arrival, the police officer spoke to Mr. Kendall and inspected his vehicle. He was asked how the accident had happened. He informed the officers about the ice. As Mr. Kendall spoke, vehicles were slowing down because of the blue emergency lights. Breathalyzer was conducted before he was placed into the care of the ambulance service by one of the officers. And thereafter, Mr. Kendall, who informed the attending paramedic that he had pains in his back and neck, was lowered into and placed on a stretcher, and he then left the scene in the ambulance. And then we get the facts at paragraph 14 and 15, which are assumed for the facts of the purposes of the appeal. At paragraph 45, in the light of the statement he's provided, the respondent accepts that the court should assume that but for the arrival of the police, it is important to notice, but for the arrival of the police, Mr. Kendall would have continued his attempts, or it might be better to say resumed his attempts to alert other road users. And equally, the appellant accepts that the police did not say or do anything, either directly to Mr. Kendall or generally, to encourage him to stop his attempts or to go in the ambulance, still less did they direct or in any way coerce or stop him to stop what he was doing and leave. And just in fairness to the Court of Appeal about this point, because lots has been said this morning that the Court of Appeal were applying some sort of test of coercion, that's simply not right. At paragraph 8 in the Court of Appeal, and it's on page page 127. Page 127. Lord Justice Stuart Smith correctly records that the reference, and this is halfway down the paragraph 8, specifically the claimant's reference in her skeleton arguments to the police placing Mr. Kendall into the care of the ambulance service implies no coercion or encouragement to Mr. Kendall to alert to stop his attempts to alert other road users. And that's also clear from Mr. Kendall's own statement.
Yes, I mean, and further above that, about 6, 7 lines down, the police did not say or do anything to encourage him to stop his attempts or to go to in the ambulance. Still less did they direct or in any way coerce.
So the point that's being made here, and the point that the concession my learned friends make in paragraph 15 goes to, is that the police didn't do anything.
No. The question is it reasonably foreseeable as a police officer that if you arrive at the scene, that fact will dissuade somebody who's already there from making attempts to help? And the answer to that, I would have thought, is obviously yes. Well, as a second question, is it reasonably foreseeable in this case to the police that Mr. Kendall would have done anything to help if they hadn't arrived? And that may be much more problematic, but that seems to me a question for the trial.
Well, in every case involving a public authority, and it's a point that I'll be coming to in the authorities when we go through them, members of the public, of course, always assume that the public authority will do its job, and indeed, members of that generally they do.
And they know that. They know that.
And that's true in the case of Mrs. Michael, who phones the South Wales Police. It's true in the case of the parents who seek help in relation to the abuse they're suffering from their neighbours. In the pool case, people will, of course, always assume that the public authority will do its job. But, as I will be submitting on the authorities, that is not the law as to when a duty of care arises.
That's not being suggested. That's not the question here. The question is whether it's foreseeable to the police that their arrival will have the effect, if anybody else was going to do something, that now they won't. And that seems pretty obvious to me that it's bound to have that effect.
Well,
they must be aware of that.
Yeah.
It's a different question whether in this case they would have had reason to expect Mr. Kendall would do anything.
Well, can I come on to that specific point? Because from the statement of facts and issues and the facts as we have them from the witness statements and the call, it is to be noted, and also particulars of claim, actually. Mr. Kendall's the only show in town when the police turn up. When the police turn up, he is not flagging down traffic. There is no allegation in the particulars of claim, or indeed in any of the evidence which has been filed since in response to the summary judgment application, no allegation that he told officers that he had been trying to warn traffic of the ice.
Isn't that in the call handler?
All that we get from the call, yes, is that one reference to he had tried to flag down a van.
And he was scared that there would be another accident.
Yes. But what we don't get from that is that he says he's carrying on some sort of rescue operation.
But this is all part of the factual inquiry at the trial, isn't it?
Well, these are the agreed facts at their highest. And on those agreed facts at their highest, the claimant does not allege that the police knew that Mr. Kendall was engaged in some sort of rescue operation or had, or even knew anything apart from the call handler knowing that he's tried to flag down a single van. And in fact, if one goes back to the call, which was at E221, paragraph 2, page 232, the controller says to Mr. Kendall, you're stuck at the side of the road, are you? I can hear other vehicles going. Mr. Kendall, they're just driving past, they're not stopping, it's 4 o'clock in the morning, they're not going to stop. But you're not in any danger at all from other vehicles. I don't know, there's ice all over the road, that's why I spun off. what the police see when they turn up is not somebody who's standing flagging down traffic. What they see is someone who is apparently injured enough to go off in an ambulance. So if one's looking at whether, if one's looking at what was called the McBride and Bagshaw exception, which involves that the police knew or ought to know that they were displacing an in situ rescuer, on the facts taken at their highest, they clearly didn't. And then I asked the court to turn to look at what this case is really about. What is the gravamen of this case? And to that, could I invite the court to turn up the particulars of claim, which I think are one of the separate documents, because some pages I think were missing from them.
Do you know when these documents were sent to the registry? Because I certainly don't have them in my electronic bundle.
I think they were sent separately with the emergency.
Or they're with the Emergency Obstruction Act?
I've got one called Particulars of Claim in my bundle.
A separate document called Particulars of Claim.
Is that the one you want?
Yes. I'm sorry. I mean, I don't know how they were missed out.
They've been put into our folder as a separate documents. One's Particulars
of Claim.
Yeah.
Yes. So I thought we were looking for something called Supplementary Bundle. No, okay.
No, and if I could invite the court to turn to page 8 of that document, which is paragraph 58, which is under the rubric, the particulars of negligence.
Page 8.
Yes, page 8 of that particulars of claim document. The very bottom is paragraph 58.
Thank you.
The particulars of negligence alleged are either individually or in concert with each other, all three of the said officers and Mr. Wilkie, the call handler, by their conduct made matters worse, in that their attendance and subsequent negligence led directly to Mr. Kendall and other drivers who would have come to his aid, ceasing his attempts to warn other motorists by vigorous arm waving and gesticulation at the side of the road. In the short time that he attempted to warn incoming cars, he had been successful in slowing traffic to a safe speed. Matters were made far worse by the attendance of the police, as had Mr. Kendall known they were not planning to attend, he would have persisted and summoned help from others, along with unknown other drivers who would have stopped in his endeavours and to warn motorists of the hazards ahead. Further, but for the attendance of the police, the fire service would in all probability have taken control and remained at the scene. What we see there is the attendance is put. The attendance itself, and my learned friend has never suggested that the attendance itself is negligent. And then we get the particulars of negligence. And they're all in terms of omissions. There's failure to carry out any form of risk assessment, failure to take any or sufficient steps to slow down the traffic. And in that context, at B13, reference is made to having placed the single slow sign and then removed it. And so on. It's a failure to prevent the further accident. And that follows through in relation to how causation is put at paragraph 67, which is...
But again, for example, E on 59E, not staying at the scene until the gritters, worded as an omission, as it were, but it could equally, as Lord Hoffman pointed out, be saying leaving the scene before.
Well, it could if you had a duty to be on the scene in the first place.
Oh yes, but what I'm saying is,
because
the omission, commission distinction isn't always very helpful.
No, but it does help to see how someone has put their case, because one has to start by looking at the pleadings to see what at heart is this case about. This is not a case like Lord Hoffman's example where the police drove into Mr. Tindall, where you have a directly caused physical injury. This is a case where the gravamen of the complaint is that they failed to protect Mr. Tindall from a natural hazard.
Well, the gravamen of the complaint is that they caused an accident which wouldn't have occurred if they'd never come along at all.
Yes, I'm going to come on to that, because what I will be submitting is that my learned friend's reliance on causation, and he doesn't shirk from the fact that he puts his case on causation. It's stated clearly in paragraphs, I think, 31 and 32 of his case, is that but for causation is obviously an important ingredient of any liability, but it doesn't do the whole duty. One has to have something more than but for causation. And of course we see that across the law, and I'll be coming on to address the cases on scope of duty where that point has been made. My Lord Burrows also made the point in the vicarious liability case, BXB and Watchtower. I'm not saying but for causation isn't an element, but my learned friend's case, I do respectfully submit, falls into error in making it do all the work.
Well, but for causation follows there being established that there is a duty of a certain scope, and that duty has been breached.
Yes. Yes.
It
comes at a later stage. And indeed, we see that in my Lord's, because I appreciate three of the panel were in the case. We actually see that line of reasoning in the Great Lakes case, which I submit is actually entirely consistent with how we submit the case and how the Court of Appeal here decided it. The Great Lakes case, which I think...
Can I just before you go in onto that, I'm just struggling with this submission at the moment. So, as I understand it, what we're concerned with in this case is to establish the very first element of the tort of negligence, which is whether there's a duty of care. We're not in any sense saying anything about what might happen at trial, about whether that duty of care was actually broken, whether or not the breach of that duty of care factually or legally caused any harm, whether that harm was too remote. We're actually right at the start. So the fact that you are saying but for is the be-all and end-all, my understanding would be it is one element that helps us here in determining that first part of the duty of care inquiry in this particular type of case. It's saying nothing about what subsequently might be decided about causation in relation to the harm that has been caused at trial.
I don't dissent from that. My point is that my learned friends are translating but for causation into doing all the work as to whether there is a duty of care. Their case is, because there's nothing negligent, we don't have to try whether the police attending was negligent. Nobody alleges that was negligent. It would be a fairly hopeless allegation to suggest that was negligent. But it's the attendance. My learned friend's submission is, well, the police made things worse because but for their attendance, Mr. Kendall, who unbeknown to the police, was planning to carry out some sort of warning system, wouldn't have left.
Well, they've accepted an argument that they'll have to show that it was reasonably foreseeable that that would or might have happened had they not intervened.
Yes.
I think you're suggesting that that is not a finding that we can go as far as say that's not a possible finding for the trial judge, but that seems to be at the moment a rather ambitious submission.
Well, I do submit actually there's nothing alleged here which could suggest it was reasonably foreseeable that he would have carried out an operation. I mean, the very nature of the making matters worse, whether it's making matters worse or whether it's an exception in prevent, is that the person only comes under a duty if they actually know or ought to know that someone else was going to do the rescue. And here we don't have even the basic building blocks of that case because it's not alleged that the police knew or ought to know.
But that is your submission, is it? That is what we need, that we have to... that in order to establish the duty of care, it must be shown that the police knew or ought to have known that rescue would, that warning would otherwise be carried on by.
It must be shown because if we're looking at if this is a causing harm case or an omissions case, and I submit it clearly is an omissions case when one looks at how it's pleaded, but we all owe a duty not to negligently cause each other harm. I mean, there are exceptions. Just because you carry out a negligent positive act, there are cases where the law doesn't recognise a duty. Brooks and the Commissioner of Police is an example of that, given in Robinson. So we all owe a duty not to negligently cause harm to each other, but that's not how this case is put, because there's nothing negligent that the police did. There's nothing allegedly negligent that they did which led to Mr. Kendall leaving. And that negligence might be established if they knew or ought to have known that Mr. Kendall was going to do something, or he...
You're saying that we need to be satisfied that the police knew or ought to have known matters about Mr. Kendall, but if the proposition is it's sufficient if it was reasonably foreseeable that Mr. Kendall might leave, why isn't that sufficient for a duty of care in these circumstances?
Might otherwise have stayed, yeah.
Yeah. Yeah, plus the causal link.
Because if one's analysing what makes things worse, or what's take the private road user who turns up. Supposing it wasn't the police who arrived on the scene, first of all, supposing it was somebody driving down the road who stopped and got out their triangle. They know nothing either, like the police, about Mr. Kendall's earlier attempts to flag down a van or other vehicles. They know nothing about the fact that he was planning to carry on some sort of rescue operation otherwise. It does seem a rather extraordinary result that whoever stops and temporarily puts out the red warning triangle that we all have in our boots these days whilst they assist him and they see him go off to hospital somehow comes under a duty of care. And I do submit reasonable foreseeability, as my lordship puts it, isn't enough, because you have to be carrying out some sort of activity to give rise to a duty of care.
Well, suppose, just to see where the battle lines are, suppose in your example, Mr. Kendall was there warning traffic, somebody else comes along and takes over from him. Would you accept that they could then be under a duty if they give up a couple of minutes after he's gone?
No, I wouldn't actually, unless they had an agreement, a discussion between them, and some sort of agreement where Mr. Kendall said, well, could you stay on here for the next sort of period whilst I go and do this? And that person says, yes, okay, I'll do that. And then they don't. Then there would be a...
It's not sufficient that it might have been obvious to them that if they hadn't come along and taken over, that Mr. Kendall, as far as could be seen, was going to carry on warning people.
No, it's not sufficient in my view, because, in my submission, because how are they to know how long Mr. Kendall's planning to do that? And if they do take on the duty, are they taking on a duty to do any more than Mr. Kendall owed, which was a duty not to make things worse? Why are they, by the fact that they stop and help, undertaking a duty of a broader scope than the person that they were replacing?
So as I understand it, your submission is that we have to find, over and beyond the proposition that's been accepted at paragraph 14, that but for the arrival of police, Mr. Kendall would have continued his attempts. You say we have to find some sort of knowledge by the police or something that would lead them so that they ought to have known that he was already warning traffic?
Well, that would be the starting point, because I'm going to take you to the
But do you say that that's not even established on the best view of the facts?
That's not established on the best view of the facts. It's not even alleged on the best view of the facts.
Before we get to Lord Legate's point about what duty existed, just to make sure I understand your case, you're saying to have a causing harm case, it has to be negligently causing harm, unless the police knew or could reasonably have foreseen that Mr. Kendall, if he hadn't departed in an ambulance, would have continued to act qua rescuer. You say that there is no negligent causing of harm.
Yes.
Yes.
And I accept that our cases, the way we put it in our case is actually based, we say, faithfully to the authorities, neatly encapsulated by Lord Hoffman and Stoven and Wise, that the making things worse involves either doing something that was negligent or there are circumstances where one is carrying on an activity which carries with it the risk that it might cause harm. And the good examples are, my learned friend referred to the examples in Clark and Inzel, where it was said that you can blamelessly create a danger. But there are examples where people are conducting an activity which carries risk. One of them is if I drive my motor vehicle. I'm carrying out an activity. I'm putting the road out on the motor. If the motor vehicle breaks down, then yes, of course, even if it breaks down without my fault, I should do something about it. Similarly, the manufacturer, which is an established duty situation, the manufacturer who puts a product for profit onto the market and later discovers there's some defect in it which couldn't have been discovered at the time, is carrying out an activity.
Yes, but we're well removed from that. In the present context, I think you are saying that making things worse in this context would have to involve doing something which was negligent.
Yes.
And are you saying, I think you are, that to be negligent in this context, they must have known that they must have known that, or be able to infer reasonably that Mr. Kendall would have been flagging cars down but for their presence?
Well, yeah, I mean, I would put it slightly more nuanced than that. I don't say that would automatically necessarily be negligence, because, but if you have a...
No, but I'm not saying that necessarily amounts to negligence, but there must be something of that nature.
There must be something at very least of that nature. Yes. There must be something that, to attract a duty of care and negligence, it must be possible to identify something that the defendant has done. If, on a causing harm principle, if a duty is simply going to depend on the happenstance as to whether of a crowd of onlookers someone might, had the defendant not acted, have themselves acted, then the duty no longer depends on what the defendant did or facts which you can look at objectively. What it depends on is the happenstance as to whether somebody can find a witness, possibly in not this case, but we all know that everybody has compulsory motor insurance. There will be accidents where somebody has an accident caused in part by the ice, where they may also be able to say the police should have closed the road earlier. The motor insurers may spend a lot of money looking for a witness who can say, well, if I'd known about it, I'd have intervened. But there must be something the defendant did.
But as I understand it, the crucial point you're making here is that the police at least need to know, or ought to know, or at least should be able to reasonably foresee that Mr. Kendall was or would otherwise have been warning traffic. And you're saying, as I understand it, that none of that we can take from the facts, even at their highest.
Yes, I am saying that. I'm saying if your lordships and my lady go and read the particulars of claim.
And what do you then say about the call handler who was told that he was waving traffic, or he slowed down?
She was told, she was told, and it's paragraph 2 of the Statement of Facts and Issues, which is taken directly from the pleading. She was told that his back and chest were hurting and he had tried to flag down a van. Nothing about why he was trying to flag down the van, but he tried to flag down a van. You know, the obvious inference would be he was trying to flag down the van to get assistance.
And sorry, can you just remind me of where that is taken from in the call handle? You did give us the reference, I'm very sorry.
It's not actually in the transcript. That allegation appears for the first time in one of the witness statements.
Well, wherever it is in the original. I'm sorry, you've already given it us this afternoon.
I think... can I just come back to you with that? I think...
Sorry to take you out of your order.
What I propose to do is, I'll just briefly look at the Great Lakes case since it's recent, but what I will then do tomorrow in more detail is take the court through what Capital and Counties said. I'm going to focus in particular on Capital and Counties and also Mitchell and Glasgow, although I'll also look briefly at Gorringe too. But in relation to the Great Lakes case, which was decided just as we completed our case for the court, so I'm sorry that it wasn't mentioned. I think it sort of came in as our case had gone out for client approval.
There's no need for an apology.
No. But the case decided on the judgment on the 21st of May 2024 UKPC 11, which my Lords Briggs, Leggett and Burrows were all in. The relevant feature I draw attention to is about the greatly named rum and coke boat, as I'm sure you will remember, and the fact it was stolen. But your Lordships dealt at paragraphs 38 and 39 and 40 with a part of the case, which was the gravamen of the case was an omission. It was a failure to prevent the boat being stolen. But the alternative submission was made that an employee of the defendant had been involved in the events, a porter who had unwittingly shown the thieves around the boat, put on the air conditioning for them, got it ready for them to sail off in it. And the analysis we submit is exactly on point here, and it's exactly the analysis, in fact, the Court of Appeal adopted in our case. It was said as an alternative submission, counsel for Great Lakes argued at first instance and before the board, although it would appear not in the Court of Appeal, that even if there was no relevant duty of care owed in respect of the failure to confer a benefit by preventing the theft, RAV was vicariously liable for the acts of O'Neill Roll, who'd assisted or facilitated the theft. In other words, O'Neill Roll, he was the porter, and his employer, RAV, were in breach of a straightforward tortious duty of care, not to harm MBP or make MBP worse off. It is not in dispute that such a duty of care was owed, but in the board's view there was no breach. Winder J said that O'Neill Roll had contributed to or facilitated the theft, but with respect, it's hard to understand what he meant by that. All O'Neill Roll had done was to prepare the vessel for sailing by turning on the air conditioning and the water pump, and to arrange the water line to be cleaned. That did not facilitate the theft in any significant sense. In particular, there was no proof he'd unlocked the vessel. Moreover, he could not be faulted for preparing the vessel for sailing and arranging cleaning without asking for ID from the thieves, because, as been explained, there was no identification system in place. Counsel for Great Lakes admitted that O'Neill Roll had provided cover for the theft, but again it is unclear what is meant by that submission. To prepare the vessel for sailing and arrange it to be cleaned did not conceal the theft. In paragraph 40, it is clear, therefore, that focusing on a straightforward duty of care by acts, there was no breach of such a duty by O'Neill Roll. And then your lordships went on to consider that there was no causation in addition to that, which I would submit is the rather conventional analysis of looking at a duty to cause harm case, which is one starts with the duty, then looks at breach, and then looks at causation. And that essentially is what the Court of Appeal did here. And if I could take the court to the judgment of the Court of Appeal at paragraph 66 on page 147, 147. Lord Justice Stuart Smith said this: the claimant's submissions attach a significance to the departure of Mr. Kendall that, in my judgment, it cannot bear. It is plain that, notwithstanding the pleading, the claimant's case at its highest is that the arrival and presence of the police caused Mr. Kendall to assume privately that they would act in a certain way, which influenced him to decide to go to hospital in the ambulance. That, as I have explained, is not a proper basis for holding the police came under a private law duty to prevent road users from suffering harm. The allegation in paragraph 58 of the particulars of claim that negligence on the part of the police caused Mr. Kendall to cease his own attempts to warn other motorists is equally unsupportable. By the time that Mr. Kendall decided to leave in the ambulance, the police had not done anything that could reasonably be described as negligent, which may have contributed to his decision. So if we were looking at this case as is this a case where the police have breached the duty that we all owe not to cause harm to someone else, that's not in fact the case as it's put.
We're talking about whether there's a duty of care in the first place.
Yes, that's what,
not whether there's a breach of that duty.
Well, I think there may be two elements to that, because, as I say, there's no question that everybody owes a duty and not to cause harm to someone else. And indeed, the head note, if you had the head note to Tindall,
we've got to be specific about that in this particular context. Whether a duty of care owed in this particular situation.
Yes,
not to make the claimant worse off.
A scope of duty is issued based on the circumstances of the case. Yes.
Well, that's one way of looking at it. Yeah.
Yes, but what I'm submitting here is that if one looks at what the duty that's been alleged here, which has been breached, is, because that's the duty that doesn't exist, the duty to, in relation to the omissions, that's what this case has been about. The case hasn't been, and it's not pleaded on the basis that the police owed and breached the duty not to cause harm, because there's no allegation of any breach of that duty. So this is not actually, in truth, a causing harm case.
But that passage from Lord Justice Stuart Smith is just saying that there's nothing that you could fault the police for in terms of contributing to Mr. Kendall's decision to leave.
Yes.
That is not the same as saying that they were not negligent, if you want to look at that now, in allowing him to leave and not putting replacement warnings in place. So I don't think that sentence actually gets to the core of what is the problem here, which is that Lord Justice Stuart Smith doesn't seem to deal with the issue that I thought you were now dealing with, which is about whether the police could reasonably have foreseen that if Mr. Kendall was warning traffic already, and that therefore if they pulled out and didn't bring anybody else in, there would be no warning to traffic at all.
The issue I submit in relation to what my Lord says is that it assumes in the first place that the police had a duty to stop Mr. Kendall from leaving. Because all the police do is attend, and if I could...
that is the key question as to what the police should have reasonably foreseen at that point. Yeah. Now, you're telling us, I think, that they just had an injured person stop. That's all they knew. There's somebody injured here, and he's going off to hospital. That is it. They didn't foresee that he was actually warning other traffic users, and nor ought they to have foreseen that. So that is as I understand it, the stark view of the facts that you're asking us to accept, that he was just being treated by the police, and perfectly correctly treated by the police, as someone who had been injured in an accident, full stop. But my understanding was that there were further points about him having tried to flag down and flagging down vehicles that the police were aware of, or ought to have been aware of, or ought to have foreseen. And that is because the call handler was told that he was flagging down a vehicle. Now, you may say that on your version of that, that meant he's an injured person seeking assistance from a van. That's not how he thought he was flagging down that van for, because we've got his witness statement that says he was trying to warn the van by flagging it down, not that he was trying to be taken off to hospital by the van. So on the best view of the facts, my understanding would be that the call handler had been told that the person there was trying to warn other vehicles. Now, are you just saying that that is not a correct or best view of the facts that we are entitled to take? Because if you are saying that, I think that needs to be made absolutely clear.
I am saying that because one has to judge a defendant and whether they come under a duty objectively, not by what's in Mr. Kendall's mind or what he thinks he would have done or what he says he would have done or what he actually would have done, but by what the defendant has done and knows, which is that at its highest, they're told that he's tried to flag down a single van. That's it. They're not told anything else. It's not alleged they're told anything else about it.
There's nothing in the witness statement by Mr. Kendall to say, when I got there, I told the police that I'd been trying to stop vehicles or slow them down because of the ice. There's nothing of that nature.
Nothing of that nature.
And it would have made all the difference, would it, do you accept, if Mr. Kendall had been standing by the side of the road, flagging cars down when the police arrived?
Well, for the reasons I submitted earlier, I don't...
You've got a second alternative argument, which is that if they weren't negligent in displacing Mr. Kendall, then they can't be liable.
But that's a separate point. I'm asking you about the duty.
Yeah.
Would they have come under a duty had he been standing at the side of the road, flagging cars down because of the ice, not to get help, but because of the ice?
Yeah. No, well, I, for the reasons I submitted earlier, I would submit actually not without something more, such as some discussion between them about what he was planning to do, some sort of assumption of responsibility, because why should one assume he's... one would need something more than that, because otherwise, as I said earlier, the driver who stops to assist him comes under the duty on those facts. I mean, I should perhaps, before we finish, because I'm conscious of the time, just put this reasonable foreseeability issue in context. Lord Hoffman, who puts these things way better than I can, especially under fire from the court, put it in Gorringe, and we've set out the passage at paragraph 29 of our case on page 103. And I will come to the authorities tomorrow because I appreciate I've been trying to put our case in context here. But he says, if the highway authority, and he's looking at the duty of highway authority, if a highway authority at common law owed no duty other than to keep the road in repair, and even that duty was not actionable in private law, it is impossible to contend it owes a common law duty to erect warning signs on the road. It is not sufficient that it might reasonably have foreseen that in the absence of such warnings, some road users might injure themselves or others. Reasonable foreseeability of physical injury is the standard criterion for determining the duty owed by people who undertake an activity which carries a risk of injury to others. But it is insufficient to justify the imposition of liability upon someone who simply does nothing, who neither creates the risk nor undertakes to do anything to avert it.
That's a different point he's making. He's saying that reasonable foreseeability, if you don't do anything, somebody will have an accident, isn't good enough. We're concerned with reasonable foreseeability that if you don't do something, somebody else will.
But that's why this is actually an omissions case. Because here, if one's looking at, is this a case where the police did something by displacing Mr. Kendall, because they turned up and Mr. Kendall left, what is it about the activity that the police are carrying out which has carried the risk of injury to Mr. Tindall, sorry, to displace Mr. Kendall? What the police, all the police do, and why the Court of Appeal were right in that passage that I took the court to, is because it followed on from an analysis of what the police had done up to that point. The police have attended, they've sought to assist Mr. Kendall, because that's the purpose of their attendance, but they've not done anything which anybody would say was wrong. Setting out to help rescue someone is not an activity which carries with it the risk of future injury inherent in it to others. So this comes back to my submission that the gravamen of this case is actually that this is a case about omission.
In the context of a review of the whole of the conduct of the defendant, which suggests that they've made matters worse. And that's why an omission-type liability gets through the door, which it otherwise wouldn't do.
Yes, but my point is that what making matters worse means, as one looks at the distinction that Lord Reid draws, for instance, in the paragraph 69.4 of Robinson, that my learned friend took the court to, making matters worse is used to draw that distinction between acting in a way which causes harm, in the way that Lord Hoffman's describing here, and acting in a way which fails to prevent it. So the omission you can't retrospectively convert what's an omission by sort of looking back and saying, well, actually, the police did something here. That something they did wasn't itself in any way negligent, didn't in any way itself carry any risk of harm. But retrospectively, that somehow creates a duty. One has to judge the duty according to what they're actually doing. Did they do something which was negligent or foreseeably caused a risk of injury?
Would that be a convenient place to adjourn?
Yes.